Welcome to the court gallery. A defendant is in court for violating his probation, and the judge can't believe the list of allegations. The state's witness describes a bizarre home invasion that leaves multiple people in fear for their lives and ends with a shocking act of indecent exposure. But the twists don't stop there. The defendant's own mother, the victim of his original crime, shows up to beg for her son's freedom, revealing even more violations in the process. Judge Stevens can't believe his ears. It's like the allegations of wrongdoing will never stop. Judge Stevens only needs one violation to revoke this guy's probation, and he's racked up a baker's dozen. Ladies and gentlemen, behavior like this is why we say, every day in the USA, people find themselves in court.
Cortland Hartwick.
Wait a minute, that's a LTRP.
Okay, we're gonna have a hearing on that.
Yes, sir.
Okay, let's see what we can get done without the hearing, and then we're gonna go to these hearings. Okay, thank you, nicely.
No problem.
And the state's ready on that?
All right, Judge.
Okay.
If I can get.
It's got 12 allegations of wrongdoing here, right? I don't think I've seen this many in a long
It's a long time. I think when that new case comes, we're gonna try to work some best.
All right. Houdini. We'll see you later. All right, we call Cortland Hardwick. That's you, sir?
Yes, sir.
Okay. And you were here with Mr. Adams, your attorney,
Yes.
and the state's attorney. There is a motion to revoke probation that has been filed as of March 24th of this year. And it alleges that you have failed on your probation in 6 different ways: by committing burglary of a habitation, by indecent exposure, failing to report to the probation office, failing to provide verification of community service hours, failing to provide verification of entering and successfully completing the Batterers Intervention and Prevention Program. We call that BIP, and failing to pay court-assessed fees as directed. All of these were conditions of probation, but the court had ordered you to follow based upon your conviction here, upon your plea of guilty to the 3rd-degree felony of injury to an elderly person. The 3rd-degree felony that you were indicted for. Do you understand where we're standing here? We're going to have a hearing on these violations that are alleged. All right, y'all have a seat, and let's put on the evidence that needs to be presented. Thanks.
Yes, sir.
Brent, for moving. Appreciate you. All right. Once again, in 22-40987, the state of Texas versus Cortland Julian Hardwick. You're Mr. Hardwick.
Yes.
Here with Mr. Adams, your attorney, and the state's attorney. Mr. Hardwick, raise your right hand. Do you solemnly swear or affirm that any statements that you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary?
Yes, sir.
In summary, this motion to revoke probation, again filed on March 24th of this year. In summary, it states that on July 25th, 2023, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison. That was suspended, and you were placed on regular probation for 10 years for the 3rd-degree felony of injury to an elderly person. Is all of that true and correct? Correct? Yeah, speak out so she can hear. Okay. Allegation 1 states you committed the offense of burglary of a habitation on or about February 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of your probation order. And your probation order number 1 states commit no offense against the laws of this state or any other state or of the United States. Is allegation 1 true or untrue?
Untrue.
Untrue will be put into the record on your behalf. 2. Allegation 2 states you committed the offense of indecent exposure on or about February 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of your probation order. Is that true or untrue?
Untrue.
Untrue will be placed in the record on your behalf. 3, you failed to report to the Jefferson County Probation Office for the month of January 2026 in violation of condition 4 of your probation order. Condition 4 states report as directed by your probation officer and obey all rules and regulations of the Jefferson County Probation Office. Is that true or untrue?
Not true.
4, you failed to provide verification of performing community service hours as directed in violation of condition 18 of your probation order. Your probation order number 18 states that you shall perform 600 hours of community service. And anyway, you have required community service obligations as part of your probation order. And is this allegation true or untrue?
Untrue.
5, you failed to provide verification of entering and successfully completing the battering intervention and prevention program. We call that BIP, BIPP, in violation of condition 27 of your probation order, which states complete BIP and pay all associated costs. Is that true or untrue?
Untrue.
And finally, this says in number 6, you failed to pay court assessed fees as directed, and you are, as of February 17th, 2026, in arrears $2,735 in cost, fees, and other assessments as part of your probation. And that is in violation of condition 35 of your probation order, which states pay the amounts required in this probation as set out in this order. Is that true or untrue?
Untrue.
That's okay. Untrue is written in, is written into the record and placed into the record on each of these allegations. State may call your first witness.
Ronnie Williams.
At this time, we will vote the rules.
There are no other witnesses besides the probation officer, Jeff.
Okay.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please have a seat. Thank you, sir.
Yeah, that works.
Thank you.
Go ahead.
Go ahead and state your name for the record, sir.
Ronald Williams.
All right, so I'm gonna just adjust that microphone a little bit and ask you to answer direction, delivering less for the first second. If that's right. There's a way to follow it. All right. If you're gonna hold it, don't hold it. Promise with that.
I'm gonna try
All
it.
right.
Hold on for just a second. I'm gonna.
If you want to mess with it, go ahead.
That's probably.
I had it said that earlier.
I know, everybody moves it around with.
Yeah. You gotta. Yeah.
All right, so
Stand by.
I apologize.
Getting the real time court reporting displayed here so I can read along.
I'm fixing to have a blast in
Okay, and again, you were Ronald Williams?
Yeah.
All right, I think when I called you, I called out the name Ronnie Williams. Do you go by Ronnie?
I go by Ron.
And your official name is Ronald Williams?
Yes.
Is it spelled RONALD?
Yes.
Williams is the common spelling? Is that a yes?
Yes.
All right, you're doing good. Where do you live, sir? Do you live here in the city of Beaumont? I don't want to get into the specific street address, but is that on Chamberlain Drive?
Yes, it is.
Okay. Do you remember an incident that occurred on February 15th of 2026?
Yeah. Yes, sir.
Okay. And did this incident occur at your house?
Yes, sir.
You are the owner.
My mother was the owner.
Okay.
She's passed.
But you are the one that currently lives there? And is there a lady that lives there in that house as well?
Yes, sir.
And what's her name?
Teresa Hayes.
All right. So what happened on February 15th, 2026?
I go to get us something to eat, me and my girlfriend. And when I come back, I'm back in the driveway. And he's coming down from across the street down the driveway.
Oh, hold on, who's he? So I wasn't there. So,
Slim's all I know him by. I don't know him. I don't.
do you see him in the courtroom?
Yes, sir, I do.
And what is Slim wearing?
Orange jumpsuit.
Is he the gentleman at the end of this table with the dreads?
Yes, sir.
Your Honor, may the record reflect he's identified the defendant.
Yes, it will.
All right, so you see Slim as you know him, and what's Slim doing?
He's walking up his driveway toward Chamberlain, which is right across the street from my house.
Are y'all neighbors?
Yes, but I don't think he actually lived there. He was, I think, visiting the people that did live there.
You've seen him out and around,
Seen him and I had said hello to him. That's it. I don't know him, you know.
right?
So,
So you see him coming, and what's he do?
so I'm sitting there listening to a song on radio. I'm going to finish listening to it. So
That's you in your car, sir?
yes, sir,
Okay.
I'm in my car. And so he turns like he's gonna go down to college, but then he stops and he comes right through my yard. What did he do? So I open the door, I get food, go towards my front door. By the time I got there, he's at my front door. And I asked, what are you doing, man? So I open the door and he just goes right on up in my house. He goes over and lays on my couch.
So let me stop you there, and I know you've got more to say, but did you invite him to come into your house?
No, I mean, everybody come in.
So all this was his choice, he just walked through your yard, came through your door,
Yes.
lays down on your couch.
The objection is that's gonna be a misstatement of testimony. I thought I heard his testimony was he opened the door. So when he
I
opened,
did open the
Hold on, everybody. When there's objection, I got a rule on it, then you're gonna have a fair opportunity to be heard. What's your objection?
Judge, the legal objection is that's a misstatement of the testimony because the client said he opened the door. So it's not like my guy's forcing himself in there. He opened the door.
The court will note what the record shows, and you will have a fair opportunity to present evidence, Mr. Adams.
Thank you, Your Honor.
When it's your turn, and to cross-examine. And the court will determine what the facts are. Go ahead.
So to be clear, Mr. Williams, you're not saying he forced his way into your house.
And he tried to burglarize or do any of that kind of stuff. He just come in, he'd lay down on my couch. I'm like, what the hell is he doing?
Right.
You know?
And again, he wasn't invited.
No.
And so once he does this behavior, do you find it out of the ordinary that this guy just walks in and lays down on your couch?
Yeah, of course.
So what do you do when that happens?
I told him to get his ass up and get out of my house.
Did he do it?
Not at first. He just laid there. And then I kind of got a little bit lighter, told him, get your ass up and get out of my house, dude. I
Right.
don't even know.
Right. So at this stage, you're getting upset about some guy you don't really know laid up in your house.
Yeah.
Does Miss Hayes come into the room?
Yeah, she's standing in the hallway right there going into the living room.
And so what happens? What's next?
She told him a couple times herself and then he get up and leave.
Let's stay away from what she said. What's the next thing that takes place?
Well, he finally gets up and he comes to the door, which I had done opened it, had the door open.
Trying to shepherd him out, right?
Yeah. So he turns around and pulls his shorts down and shakes his crap at my girlfriend.
Now
When
let's,
he done that, I really got.
I'm gonna need you to be specific. He pulls down his shorts and he shakes what? Let's use the,
It's pain.
thank you.
We're adults here, so it's not gonna embarrass us too much, but we need to know exactly what you're a witness to. Thank you.
Remember, Mr. Williams, it's all about holding somebody accountable for the conduct. He shook
Well,
his, all
evidently his mind wasn't right or something.
right,
But
don't go guessing. This man pulls his shorts down and waves his penis at you and Miss Hayes.
yeah,
Were you offended by that conduct?
well, of course I was.
So you're already upset about him laid up in your house doing this. Now he does that. What do you do?
The shit out of it. My language was, yeah, I hit him and knocked him out the glass, the screen door,
Knocked him out of your house?
knocked him out of my house, and he lands out there in the yard. So I run out there and he hit him, and then my girlfriend was telling me to stop. And so I did, but then he jumps up and runs on across the street, and I told him, let him see his dad out here.
You ever apologize for that conduct?
It was like 3 nights later, there was a knock on the door. I'm thinking that one of the TVs. It's him. I'm like, what the hell? I said, man, get your ass out of here, dude. And he did. That was about it.
Any doubt in your mind that whenever he was in your residence, that you gave him notice that you wanted him out, that he was an unwelcome visitor?
Could you repeat that?
Is there any doubt in your mind that when all this is taking place, you let him know you wanted him out of your house?
Well, yeah, they know.
And he didn't do it initially. You basically had to force him out.
Well, yeah,
Well,
yeah,
I mean, your punch
yeah,
took him out of the house.
yeah.
And all that conduct that he did was not by your consent, meaning you didn't agree to all that to happen, correct?
No, I think it's good.
So some of the questions we have to ask about legal elements are kind of wordy, but that's why what I needed to ask you, sir, was without your consent. Just like him exposing himself to you and your girlfriend, Miss Hayes. Y'all found it indecent and it was inappropriate, correct?
Yes,
And all this occurred within your residence there on Chamberlain here in the city of Beaumont within Jefferson County, Texas, correct? That's witness.
How you doing, Mr. Williams? You doing okay?
yeah, I'm doing okay, yeah.
All right, my name is Langston Adams, and I represent Mr. Cortland Hartwick, and he's to my right, all right? All right, now, when I heard you testify, I wrote down 3 things that I heard come directly out of your mouth, all right?
Okay.
And not anybody saying this but you, okay?
Your Honor, I'm going to object to the format of this question. We don't need Mr. Adams to repeat what he believes. We need questions and answers.
Hey, overrule. Go ahead. So again, before the objection was made, I noticed 3 particular things that came from your mouth, and I want to go through those particular things, okay?
Okay.
Right. And you also heard the judge say that I have opportunity to cross-examine you when we mentioned some of those things, right?
Yeah.
All right. One of the things that came out of your mouth is that when my client approached the door to your home, you said you opened the door. Was that correct? That when you said that?
Yeah.
All right. And another thing that I heard that came out of your mouth, you said word for word, I'm not saying he was burglarized in the house. Do you remember when you said that? Right?
Yeah.
And that came from your mouth. And then another thing that I heard you say that came directly from your mouth is You said apparently, to use your exact words, you didn't say apparently, your exact words was evidently he was not in his right mind. Do you remember you saying that, right?
Yeah.
All right. So just beginning my cross-examination with those three things that you said, and it was unsolicited by me, it was under direct testimony with Mr. Ham. Let's talk about when you said evidently he was not in his right mind. Did you know that he suffers from bipolar disorder? Did you know that?
No, I don't know the man. How would I know that?
I got you. Did you know that he suffered from schizophrenia?
I have no idea.
Did you know that he suffers from PTSD?
Ooh.
All right. And did you know that he suffers from anxiety disorder?
Sir,
I got
I
you.
have no idea about that man.
That's a no.
The answer is no. And did you know that he went to Spindletop MHMR for treatment? Did you know that?
Ooh.
All right. So in terms of let's talking about what you do know, I think Mr. Ham had asked you something to the effect of was he one of your neighbors? So my question to you is prior to this incident in February of 2026, when was the first time you had any contact with my client ever?
Well, I really can't answer that question. I mean.
He can't answer it.
Month or
Answer.
two,
Gotcha.
a month or two before, or a
Okay.
couple months.
So in that month or two that you had known him before or seen him around before, how would you describe him?
I mean, I really can't say. I just said hello and he said hello back. That's basically about it.
Okay. So if I understand your testimony, you identified him as Slim. Is that something that you used to call him in the neighborhood?
That's what I knew him by, Slim, yes.
And how did you get to know him as Slim?
By, neighbors. I heard them calling him and go.
Okay. So basically, this is a guy that you've seen before in the neighborhood, and you heard neighbors call him Slim. Is that right?
Yeah.
All right. So in that month or 2 months or however long that you've been knowing him, had you ever seen him to do anything out of the ordinary? All right. So here's a guy that you've known at least for a month, 2 months.
I did.
Well, not know him personally, but
Oh.
I got you, but you knew of him as Slim, right? And even though y'all didn't have a personal relationship, within that 2 month period, you did not see anything out of the ordinary with him. Is that right?
That's right.
All right. So then when we get to this particular day, obviously something happens out of the ordinary, right?
I think so.
Right. And when you said that, hey, I'm not saying that this is a burglary or anything like that, because when we talk typically of a burglary, you got somebody forcing their way in your house, they wanting to steal something in your house, something like that, right? Right. But in this case, what you got is a guy who, according to you, evidently he wasn't in his right mind. According to you, you open the door, he walks in your house, he sits down, and he's not in your house trying to steal nothing out of your house, right?
Yeah, right.
He's not in your house saying that he want to fight you or beat you up or threaten to beat up Miss Hayes, because I think under your testimony with Mr. Ham, your testimony was, in fact, you hit him when he took out his penis, right?
Betcha. And he's lucky. I mean, somebody else might have shot him there.
Yeah, well, no doubt about it. And I totally understand that. I totally understand that why you would be upset if you had a man in your house who you had let in. He sits on your couch or sofa, whatever he's sitting on, and he's displaying what you call to be irrational or, behavior that's not rational, right?
That's right.
All right. And I can see why you'd be upset about that. And at the end of the day, what you have here is Slim, who you know as Slim, as somebody who appears to be psychotic, right?
Can you answer that?
Well, can you
know
answer
what
that?
psychotic means,
Yes, sir, like,
medically?
well, but
Can you answer that? Can you answer what you understand psychotic to mean?
Or do you have the ability to make a psychological evaluation of another person?
I'm not asking you to make one.
Qualified to make that statement, Jack.
Do you have any medical training at all on this? Okay, but you got experience in life.
but you know,
All right.
Right. And
Yeah.
based upon your rule,
I'm sorry, the objection is sustained. He doesn't, you're asking him, we're gonna go into psychological questions that he is unable to ask.
I'm not
But
going
we
to.
can, we're just talking about
I'm not.
figuring out what the facts are in this case. He doesn't have the qualification to make a medical or psychological determination. So go ahead. He's a witness to what he saw and he's doing the best to try to explain it. Go ahead.
So you understand that you're not a doctor, you're not a psychologist, you're not a medical provider, you're not a counselor, right?
that's right.
Right. But you are a lay person, right? You're a person with common sense, right? You got eyes, you got ears, you got your senses, you can see, right? And you don't have to be a doctor or psychologist to see something strange, right?
Right.
And in your own words, you said apparently he was out of his mind, and then you're not a psychologist to be to see that, right?
Apparently, I thought he might be on something, you know.
Gotcha. So do you understand that I'm not asking you to make a medical diagnosis? I'm asking you to tell me what you saw with your own eyes.
I done told you that.
Okay, and I'll move on. Thank you for your time on that. Miss Teresa Hayes, did she provide any statements to the police, to your knowledge, as to what she saw or did not see? Because I don't see why I got it.
She wrote a statement.
Oh, she did write a statement?
Yeah.
And do you know where she is right now? Is she available?
Yes, she- My,
Okay. As far as with him taking out his penis, is it your testimony that he was doing that just because he out of his mind, or he was doing that for some type of gratification? Do you know?
I don't know why he done that.
Right. So I'm sorry, go ahead.
I have no idea why he done that,
Got you.
but he should.
I got you. So your testimony under oath is you don't know what was the reason for doing that. It's just that he evidently wasn't acting in his right mind. I got you. With that being said, Mr. Ronald Williams, I thank you for your time. I appreciate you.
Alright.
All right.
Your Honor, I ask that you be excused.
All right, you are excused, sir. Thank you. Next, please.
Mr. Ruiz.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony that you will about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand, thank you.
All right, so let's get you state your name for the record. We'll check the microphone here.
Jesus Ruiz.
Oh, good. And what do you do for a living, sir?
I am a community supervision officer in Jefferson County,
And how long have you been working in that capacity?
about a year and a half.
And in that time frame, have you had an individual by the name of Cortland Julian Hardwick on your caseload?
Yes, I have.
Do you see him here in the courtroom today?
Yes, I do.
Can you point to him and identify something that he's wearing?
Orange suit.
Your
I
Honor,
don't have a legal objection, but I couldn't hear him when he said the time period that he had my client. I didn't hear.
Yeah, could you repeat that? The time period that you were,
how long have you had him on your
Yes.
caseload?
Since I started,
Which was how long?
a year and
Okay.
year and a half.
So approximately 18 months?
yes,
All right.
Been his probation supervisor.
yes, sir.
Thank
So
you.
back to, I believe that you identified the defendant. Your Honor, may the record reflect that?
Yes, it will.
Thank you, Judge. All right, so Mr. Ruiz, in general, how was Mr. Hardwick as far as going, how did he do on probation?
It was doing pretty good.
Okay. Was he compliant with what he needed to do?
For the most part, yes.
Now, I see from the administrative hearing that we did have one prior administrative hearing where I think we were dealing with him in Spindletop.
Yes.
Has he been compliant with that?
Before,
Medication, things of that nature?
up until this new offense, yes.
All right, so this new offense is from February 15th to 2026, correct?
Yes.
All right, did he report to you that he was arrested on these charges?
No, he did not.
Okay. So how did you learn about it?
I saw it, on the police report, on the arrest report.
And was it after that you processed this administrative hearing and the motion that we're dealing with here?
Yes, I did.
All right. And you're a part of the mental health initiative caseload, is that correct?
Yes.
So for the purposes of the record, tell us what that means.
So I'm the mental health initiative officer. My caseload involves, people on probation that have mental health issues.
All right, so they are competent, correct?
Yes.
And
Objection, same objection that he raised. He's not qualified to make a medical diagnosis as to whether or not.
I will rephrase.
Sustain, he's gonna rephrase. Okay, it had been answered and he can amend his question and your objection
To
sustained.
your knowledge okay, do you get people on your caseload that are incompetent?
Yes, I have.
Where they've previously been found incompetent, but they have to be competent to be dealt with in the court system, right?
I would imagine so, yes.
Are you familiar with that? Okay. So let's go to the other accusations. You alleged in the administrative hearing that he failed to report in January of 2026.
Yes.
When was he scheduled to report?
Can you ask the question again, please?
All right, so the accusation is that he failed to report in January for the month of January 2026.
Yes,
My question to you was, when was he supposed to report?
on January 8th.
Okay, did he report? Did he contact you about failing to report?
Yes.
So tell the judge what happened with this accusation.
During that time, he had been sick, with COVID, with a host of illnesses, and he was in contact with me about nothing to do with the report.
Did he contact you before or were you contacting him after he missed that appointment?
Oh,
Okay. But you've alleged that he failed to report.
yes.
Okay. When was he scheduled? When was his next appointment?
2 weeks afterwards.
Did he show for that?
No.
So he missed January 8th and then he missed January 22nd? Are there any other? That's a yes?
Yes.
Did he miss any other dates in January?
No.
Were those excused?
No.
So they are considered failure to report,
Yes.
correct? Okay. Let's go to his community service hours. He's been on probation on this matter since July 25th of 2023, correct?
Yes.
And am I accurate that his probation order states that he was to do 600 hours of community service?
Yes.
And that, as with everybody else in the department, it's recommended that he do 50% within the first year.
Yes.
So by July of 2024, he should have done 300 hours
Yes.
and be well on his way to completing that. Where's he at on community service?
Completed 4 hours so far.
So out of the 600, he's done 4.
Yes.
When was the 4 that he did?
On December 24th, 2024.
None since then?
No,
Any excuses why?
he was working.
Did you confirm that he was working?
Yes.
So that connects with then his ability to pay court assessed fees, right? You had proof that he could pay?
Yes.
Why wasn't he paying?
He had a lot going on.
That's what he was telling you? All right. We all have a lot.
Going on?
We all have
What's
a
that
lot.
mean?
Yeah. Did you excuse his arrearages?
No,
But he could have paid according to the information you have.
yes,
He was working
yes.
up until he got arrested on this.
I'm not sure up until he got arrested, but months before he got arrested, yes, he was working.
Okay. And you confirmed it.
Yes.
All right. So let's go to the last.
Hold on,
Yes, sir.
just let me get clear on something, since these are parts of the allegations of the motion to revoke probation. On the community service, he's completed 4 hours.
Yes, sir.
And 4 hours, and that is from the time he was placed on probation on July 25th, 2023, essentially 3 years ago.
Yes, sir.
4 hours,
Yes, sir.
3 years, that's a grand total of less than 1 hour a year.
That's a yes, John. Yes. He's nodding his head, but he's
Yeah.
not answering.
Okay. All right, and what did he say? He was busy doing other things?
He was working.
Working?
Yes.
What was he doing for
He
work?
was working at KFC.
Frying chicken?
Yes.
Was he working 24 hours a day there?
Not to my knowledge. No.
Okay, it was like regular 8 hours shifts or something?
Yes, sir.
Okay. Did you get income statements from him? Were you able to get income statements?
No, sir.
So how do you verify he's actually working? And other probationers? How do, if they just tell you, I mean, trust, but we verify, right?
Yes, sir.
Okay, what we've done to verify what he was actually doing, especially in light of the fact that he must be he apparently, according to him, was working so hard he can only do 1 hour a year of community service.
Well, multiple times he reported in his KFC outfit. His attire that he wore to KFC.
And that was his, not something he found on the road?
I cannot confirm it.
Okay, so we really don't know because, all right. Okay, and as far as arrearages and money, what was the total amount of money that he paid for his costs for being on probation during these 3 years?
He has a total credit of $307.
Okay, so a grand total of about $100 a year.
Yes.
Okay, which is a grand total of about 30 cents a day.
Yes, sir.
Go ahead.
Batters treatment program. It's alleged in this motion that he failed to provide verification of entering and successfully completing.
Yes.
What's going on with that?
So he didn't qualify to do the intervention program, so we had him doing the anger management program. Something he did complete, he showed that he completed, but I never got a certificate for it.
Why didn't he qualify for batters intervention program?
There are certain stipulations with batters intervention that qualify or don't qualify you. And when I spoke with my supervisor, she advised that anger management would be better suited for him.
Okay. When did y'all make that change?
This was done before, well, I found out about it, but this was done before I started working.
Okay. And he claimed that he did it.
He came into my office during one of the reporting days and he showed me on his phone that he completed the 8-hour anger management course. Yes, but I never got a certificate of completion.
Is that the purpose of this? Is that we don't have proof, we don't have verification that he successfully completed the program?
Well, objection.
Oh, wait, hold on. Well, he asked a question. What's your objection?
Legal objection is that misstates the testimony when he asked him when you don't have verification. He did have verification because he showed the phone and what he completed. That is verification that and the guy acknowledged that he completed the anger management program, and my client showed him the phone that documented where he completed the program.
Okay.
He just said that.
Okay.
So he does have verification.
Okay. Overruled. He can answer the question and you can follow up with your questions. Yeah, unless you want to take the stand.
I don't know, okay.
Does the department accept people showing them something on the phone? No. It's a good indicator that maybe they did it, right? Yes,
Yes.
is that a yes? And did you give them instructions about that you needed actual verification?
Yes, sir.
Did you ever get it?
Yes, sir.
And to be clear, it wasn't for the batter's intervention program, it was for the anger management program, which is 8 hours.
Yes, sir.
The batter's intervention program is a much longer program, isn't it?
I'm not sure.
Okay. You're not that familiar with that one, are you?
No.
That's
Before we go on, let me get something clear on this, since it states in the motion to revoke probation, failed to provide verification of entering and successfully the battering intervention and prevention program. What are we doing with that?
He explained in his testimony, Judge, that the department changed that requirement to the anger management.
When did I sign that? I didn't order that.
That's
I ordered batterous intervention. I didn't order. Is there something, I know y'all changed that, but y'all, it's my order.
Yes, sir.
The courts, the district judge's orders, I can't see an amended order anywhere here. My order is for him to complete batter's intervention. Now, things can change. But it says 27, complete BIPP, batter's intervention prevention, not anger management. I mean, he's not ordered, he wasn't ordered by me to do that. He was ordered by y'all. That's not, I don't think that's valid. That's apples and oranges. When they change it, I think I have to verify it, and he's under my direction and my orders. Yeah, that's not the way I want it done, and I don't think any of the judges want it done that way. Y'all can change that without getting the approval, but I'm looking, are you certain there wasn't an amended order sent? Does anybody in probation? I'm looking through here, that's what,
On the.
I didn't order him anger management, and that's what the testimony is, but the allegation is BIP. And they're not,
I don't know what the PSI says, but the general condition for that says the BIP program or an approved anger management, but I don't.
I
think
have
that was done.
27, complete BIPP is handwritten in blue ink and pay all associated costs. I don't have any other program.
Nope.
I think I don't think, we're talking apples and oranges.
Yeah.
I know they're similar, but but apples don't want to be called an orange. Yeah, I don't see any other amendment here too that modified that. But that has to be run by the motion to revoke probation is alleging violations of the court ordered probation terms, and that wasn't ordered by the court. And so thus anger management is a good thing, but it's not what was required by the court. And the allegation is BIP violation. He didn't violate the BIP. He didn't take it, but he was told to do anger management, and he did that. I don't think how that can be used to violate as a violation of probation.
a lot of the testimony, Judge. I'm going to abandon count 5. If that's the insult.
So with that being said, you do agree with Judge Stevens and understand that the state is now abandoning 5, and I go with the rest, that without Judge Stevens' approval, you guys told him to take anger management when the court required him to take the BIP program, right?
Yes.
And that's the probation department that made that decision without the court's approval, right? Right?
Yes.
All right. So with that being said, since the state has abandoned 5, we will now move to 1, 2, 3, 4, and 6. Okay.
Yes.
All right. Now with Mr. Ham, he mentioned that you had my client for 8 months, and that 8. I'm sorry. I apologize. You're correct. 18 months, and that you are one of the people who work on the mental health, I think you call it initiative caseload, is that right? So with that being the case, I'm assuming you have some specialized knowledge about people with psychological and mental health conditions that everybody else don't have because you got assigned to this particular unit, right? Why were you assigned to this particular unit?
Thank you. That was a better question.
Why?
I was hired on as the mental health initiative officer.
Okay. Do you possess any knowledge or training that deals with people who have mental health issues?
Not qualified, not certified, no.
Okay, so you don't have any particular, so you're saying that the Jefferson County Probation Department hired somebody to work with mental health that has no credentials, no qualifications, nothing with dealing with mental health people. That's what Jefferson County did, right?
We don't prescribe or guide.
I heard you, but I got it. You don't prescribe, but you assigned to this particular division, and in being assigned to this particular division, you have no kind of training, seminars, nothing with dealing with people with mental health issues, right?
Correct.
That's all I want to know. All right. So now, with you mentioned that my client was going to Spindletop MHMR. What do you understand Spindletop MHMR to be?
It's a mental health clinics
And what do they do?
providing health diagnosis and medication.
All right. And I want to follow on the same line of questions that Judge Stevens asked you when it came to verification. Remember when he was asking you, how do you verify employment? And you was talking about how he comes in the KFC uniform and how do you know that was the questions of the judge, right?
Yes.
All right. So I'm gonna ask you the same line of questions when it comes to MHMR. Do you verify any type of mental health illness?
Yes.
Do you verify who the doctors are?
Yes.
Do you verify any prescriptions that was given, right?
Yes.
So with you doing that, and I'm just following Judge Stevens' line of questioning.
Just answer your question.
Okay. Did you verify and did you know that my client suffers from bipolar?
Yes.
Did you verify and you know that my client suffers from schizophrenia?
Yes.
Did you verify and did you know that my client suffers from post-traumatic stress disorder?
Yes.
And did you know and verify that my client suffers from anxiety disorder?
Yes.
Right. Now, specifically, since you verified, who were the doctors at Spindletop MHMR that he was seeing?
He was seeing Dr. Chan.
Dr. Tran?
Yes.
And specifically, what medications was he prescribed and what do they treat?
He was taking oxcarbazepine.
And what does that treat?
We found that with
Okay, so oxcarbazepine is what you said?
oxcarbazepine.
Oxcarbazepine, that's one. Okay, what was the other one he was taking?
Gabapentin.
You said gabapentin?
Yes.
And what does gabapentin treat?
That is for his anxiety.
Anxiety? Any other medications was he receiving?
Hydroxyzine.
Hydroxyzine? And what does that treat?
That's for his mood stabilizing.
Mood stabilizing? And what else?
And trazodone.
Trazodone. And what does trazodone treat?
That's a sleep medication.
That's a sleep medication?
Yes.
Okay. With him having a known diagnosis of schizophrenia, did you know that he hears voices?
Yes.
And did you know that sometimes he sees things?
Yeah.
And did you know sometimes he hears voices and sees things that aren't really there?
Yes.
Right? Now, with Mr. Ham indicating that you had him for, as I corrected myself, 18 months, while you were dealing with him, did he display any kinds of behaviors that you would have considered to be unusual?
Whenever he reported to the office visits,
Yes.
or whenever I saw him out in the field,
Both.
nothing.
Nothing. And did you hear Mr. Ham's first witness? Because you were in the courtroom, right?
Yes.
Remember when I said, invoke the rule, and then Mr. Ham says only one witness, and that would have been you and Mr. Williams. So you heard the whole testimony, right? All right, and then you hearing the whole testimony when Mr. Williams was here, and I wrote down what he said. He said evidently.
What's your question?
My question to you, did you hear? That's a question. Did you hear that witness say evidently he's out of his mind? Right? You heard him say that, right? All right, and you heard that witness say, "I'm not saying he's trying to break into my house." You heard him say that, right?
Yes.
And you heard him say he opened the door, right? You heard all of that, right?
Yes.
And so if we look and we focus on, because remember the state has abandoned 5, so now I'm gonna focus on 1 and 2. If we look at February the 15th of 2026, you have a 18-month history with this man, at least according to Mr. Hamlin questions, right?
Yes.
You have opportunities to see him in the field. You got opportunities to deal with him one-on-one in your office, right?
Yes.
And in that 18-month period, you, by your own testimony, has never seen anything with him that even resembles what the testimony was on February the 15th of 2026, right?
Yes.
And that's your personal knowledge, and that's what you got absolute knowledge of because you were there. You got your own eyes. You saw what you saw, right?
Yes.
Right? So when you first learned of what happened on February the 15th of 2026, did you say to yourself, man, this can't be my client? I've never seen anything like that before, right?
Mhm.
Right? Could you say, hey, that's not how he normally behaves, right?
Yes, that's
Right.
how he normally behaves, but I wasn't.
Right? So with that being said, if that's not how he normally behaves, if that's not how he is interacting with you, you might want to believe Mr. Williams when he said, hey man, this man is kind of out of his mind, right? You might want to believe that, wouldn't you?
Yeah.
All right. And for purposes of this motion to revoke his probation, if he's out of his mind, he don't know the difference between right and wrong, then we might not, what's the,
Let him ask his question.
Yeah.
And then
It's
you
not-
can,
Yeah.
let him ask his question and then you can raise your
Right.
objection.
if,
Ask your question.
if according to, I haven't asked the question.
Ask your question
Let me
and
ask
he
the
has a fair opportunity to object. Just complete your question.
All right. Again, you just said that you agreed with this Mr. Ham's witness that he appeared to be out of his mind, right? Now, my question to you is, a man who appears to be out of his mind and don't know right from wrong, we should revoke that man. We should keep him on probation and get him the treatment that he needs, not revoke him, right?
Objection.
Would you agree with that?
No.
Objection.
He,
He had made a legal objection. I'll just keep saying
hold on,
objection.
hold on. I overruled the objection. He's answered.
All right.
Ask your next question.
I'll move on to another topic.
Thank you.
All right. So, with that being said, that we could keep him on probation. If we were to keep him on probation, right? And we know about this incident of February. What services, since you are the mental health officer for what Mr. Ham asked you about as the mental health initiative caseload, what additional services could you provide for my client?
Could I provide?
Well, the probation department provide. I won't say I. What could Jefferson County Probation Department provide for him? I'll get him set up with.
For his mental health?
Yes.
Continuing spinal tap if he needs to go to a treatment facility for a prolonged period of time, we allow that.
Right. And at the end of the day, what's better for him, because you've quite sure heard Judge Stevens brag about the department. We got a great Jefferson
What's
County.
your question?
Well, here's the question I'm
You've
asking.
all heard.
Would you agree with me that the Jefferson County Probation Department works very well in meeting the needs of his clients?
Yes.
And in working very well to meet the needs of his clients, wouldn't you agree with me that you would be willing? The question is willing. I'm asking a question. Would you be willing and able to continue to work with my client? That is a question. Would you be willing and able to do so?
Yes.
Right. So since you would be willing and able to do so, your department is an exemplary department.
Yes.
Let's keep him on probation. How about that?
That's up to me.
Okay, got you. Now,
Did you hear his answer?
he said it's not up to me.
That's, he's absolutely right, isn't he?
You
All right,
absolutely.
any other questions you
I
want
want
to
to
answer that don't have anything to do with his decision making?
No, Judge, I was gonna move on to.
Thank you.
I-
Let's go, move
All
on.
right. So I dealt with 1 and 2, I dealt with 5, they abandoned. So let's move to 3 and 4 real quick. All right. On number 3 with the failed to report, I understand your answer is that he had pneumonia at that time, didn't
He had a host of illnesses. Yes.
he? Pneumonia was one of them, right?
Yes.
COVID was another one,
Yes.
right? And then what was the other illnesses he had?
I don't.
So I just got a question, and I'm not trying to be funny, sarcastic, or anything like that. But Langston Adams has pneumonia. Langston Adams has COVID. Are you telling me you want Langston Adams to come to your office and report with you? Or you want Langston Adams to be within breathing distance of you?
No.
Okay, so for purposes of on the allegation, he failed to report. And I think Mr. Ham mentioned 2 days in January. Well, that'd be a good reason for my client not to report. If he has COVID and he has pneumonia, I don't think, the prosecutors want somebody like you or anybody else want them in their office reporting with pneumonia and COVID, right?
But that's to a certain extent.
Okay.
COVID
But
and pneumonia don't last forever.
I got it. They don't last forever. But again, you can testify under oath to Judge Stevens that a reason for him not reporting in January would have been COVID-1, pneumonia-2, and a host of whatever other issues that you said he had, right?
Correct.
All right. That's what I wanted.
Who diagnosed him with those? Did you receive some medical paperwork or something that verified? Since I don't think he's a medical physician. And you gotta, we trust, but we verify. What's the verification that showed that he had a medical problem?
He went to American Family Care Urgent Care
Yes,
on 3195 Dowden Road. And this was on November 10th of 2025, where he was diagnosed with COVID.
well, who says that?
The provider.
Okay, you have something in writing that verified that he had been diagnosed with an illness
Yeah.
by
Of a medical provider.
a medical
Yes, sir.
provider? Okay, and you trust that's a valid document?
Yes.
Okay. Go ahead.
So basically, in answering Judge Stevens' questions, you did verify the pneumonia, the COVID, and whatever else that was wrong with him, and that would be a justified not to go report. It got a contagious disease. All right. Let me move on to
Wait,
the.
hold on. He didn't answer anything. You just asked him a question. He didn't answer.
Would you agree with that?
Again.
You answered it.
The date was for November 10th, 25. He didn't report in January 26th.
Okay, I got you. Let me move on to the next thing. That I'm looking at 5 real quick. I'm sorry. We
5 was abandoned.
5 is banned. I apologize. 4 is what I meant.
Failed
He failed to provide verification performing
Yes.
community service hours, right? Do you recognize the lady to my right? I think that's his mother. Do you recognize her?
Just earlier.
Okay. On the failure to provide verification, right? Did you not make it absolutely clear that that if he was working and he was working at KFC, didn't you make it clear that he would not have to do that community service while he was working? Didn't you make that clear to him?
I didn't make that clear. I said whenever he didn't work, he needed to come in.
Okay. How many hours was he working at KFC?
It depended.
What was his normal work schedule?
I'm not sure, but because he was at different KFC locations.
Okay. To your knowledge, has he completed any community service?
For him.
Okay. And to your knowledge, with him working, did he have a pretty heavy workload?
No, I'm not sure.
Okay. And then the last thing is 6, the arrears of 2,738. I believe that's where Judge was at. I'm reading 2,738. That's when Judge was asking you about verifying his work, et cetera, et cetera. Remember that? Okay, so I guess my question as a part of that verification, do you know what his monthly expenses were?
No.
Do you know if he was in debt to anyone? Do you know in terms of our essentials as human beings. We need light, we need water, we need clothing, we need shelter, right? Do you know with that income whether or not he was able to meet those essential things that every human being needs to meet? Do you even know?
He was living in a nice house.
Okay. He said he lived in a nice house.
Pretty nice house.
Where was that? Whose home, is that his home?
I'm not sure if that's his home.
Or you don't?
Who home was it?
I'm not sure.
Okay. Do you know in this nice house? I got you. So basically, I guess you're saying that while your guy's on probation, you're supervising him, you didn't even know the name of the person whose house he was living in, right? Uh,
What was the address? Do you know?
Um, 2430 Guzman.
That's his mother's address, isn't it?
he said he didn't know.
No, I'm looking, that's his mother's address here in the court, in the papers. Right? You know? You don't know?
He's saying no.
That's not.
What's his mother? It says 2430 Guzman is his mother.
2430 is Ebony's house. I was staying with a girl I was dating. That's 2430 Guzman. Her address is 2438. It's
Next
further
door.
up.
Is that next door?
No,
What's on, it's on, got to be on the same side of the street.
it's further up the block though. It's like her house is about a mailbox. Ebony is about an office in the front of the neighborhood.
He's saying he didn't. Okay. Well, I guess my point that I'm making to you is wherever he stands, you didn't know who specifically he was staying with, right?
His girlfriend.
Well, he just said that. Now, so you saying the girlfriend?
I knew that.
Okay, and what was
I
that?
didn't know who owned that.
And nobody else says otherwise.
Okay. In terms of meeting his expenses, do you know specifically why he could not pay that $2,735?
I don't know. A lot of our probationers have the money, but they decide not to pay.
Well, we're not talking about the others. We talk about him. Well, let's say this.
Personal experience.
Oh,
Tell me.
all right. You told Judge Stevens earlier. You said, I'm gonna use your exact words. You said, "Hey, he has a lot of things going on." And Judge looked up. Well, we all got a lot of things going on. So I guess I'm gonna follow up on that question by asking you, for him specifically, what are those a lot of things that he had going on for him?
No, he was dealing with his illnesses. He was working, and he said he had problems with his family.
Okay, so illnesses, he was working, he had problems with his family. Would you agree with me, and that's a question, would you agree with me that that's something we could use with Judge Stevens to mitigate this, to say, keep him on probation, don't violate him, look at all of those things, to use your language, that he was dealing with and working with while he was on probation? I'm using your language. Do you follow me?
I follow you, but I don't agree.
Okay. I thank you for your time. I appreciate you. And I think the state said you were gonna.
Family. What's the problems with the family also?
He wasn't always at his house.
I'm sorry?
He wasn't always at his mother's house. Sometimes they had disagreements from what I remember in our conversations. It was minuscule problems. It wasn't anything.
What was it about disagreements with his mother?
Yes.
What do you mean?
He would tell me they just didn't get along sometimes. And then he was staying with his girlfriend. It wasn't anything big in particular, but he said he just had a lot going on with family life.
Really? Well, that's odd. He's not supposed to have any contact with his mother. She's the victim of this crime that he assaulted her. That's why he's on probation. He assaulted that lady. He's not supposed to have any contact unless I approve it. He's been contacting, dealing with? You're kidding me?
I haven't been staying with
No. He says you've been associating with her. I'd allow it under circumstances, but she's the victim. You assaulted your mother. God bless you. Who does that on this planet? You're convicted of assaulting your own mother. And you can't have any contact with a victim.
That's in your probation order unless I approve it. Shame on you. Anything else? It's just what happens in these hearings. I find out information that I probably should have been known about. Because I'm supervising, and apparently the rules don't apply, especially my order.
From my experience, just because they're on medication or just because they're off medication doesn't mean that they're less or more likely to commit a crime.
Thank you. I know that. I appreciate that. Thing is what I am concerned about is actions of free will that are contrary to the court orders. Go ahead.
I don't have any other questions.
I don't have any additional questions. I have
Needs
to be
excused.
excused.
Yes.
State rest.
Yo, we have a witness. We call Latrice Talley. And it's not gonna be long.
Solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Lower hand. Thank you. Be seated. Thank you.
Would you
Go ahead.
I'm sorry. Would you state your full name for the record?
The actress Tally.
And Miss Talley, what is your relation to my client, Mr. Hart?
Mother.
And you're his biological mother, is that right?
Uh,
And as far as the underlying case, which is, I believe, the injury to the elderly, as Judge mentioned that you were the
Victim.
complaint, well, in that case, right?
yes, sir.
And just to get this out, while my client has been on probation, has he done anything to you that you would consider to be out of ordinary, wrong? That has he did anything to make you uncomfortable, anything like that?
Not literally, no.
All right. And matter of fact, let me be specific and candid to the court. You reached out to me to come testify on his behalf. Is that right?
Yes.
Right.
That's right.
Right. I didn't solicit you. You solicited me, right? You came to Langston Adams. Langston Adams didn't come to you. Is that right?
That's right.
And with you coming to Langston Adams, you the one who wanted to come to Langston Adams' office to come speak for your son, right?
Right.
I didn't ask you to do that, did I?
No, you did not.
You did that on your own.
Yeah.
I'm
So-
sorry. What?
Okay. So,
Yes, you're leading. Go
okay.
ahead.
Well, I just want to make sure. So with that being the
It's
case,
like, just tell the court in his own words what you know about this.
okay.
These are your thoughts. He's helping you along, but I want to make sure that you know if he's not saying something that's accurate, you were there, he's not necessarily there, let me know.
Right.
It's clear. I need to know what the truth is,
Okay.
notwithstanding the way the question might be asked.
All right.
Go ahead.
So let's get to these particular allegations, ma'am. You've been in the courtroom, right? You heard from the probation department, and you also heard from Mr. Williams, right?
Yes.
All right. And Mr. Williams described,
Judge, didn't Mr. Adams invoke the rule?
and we said
Allowed
no.
a witness to stay in the court?
Yeah, because you said no. You said
I had no other witnesses.
I understood that to mean that when I withdrew that request when he said that.
He did not withdraw.
I did. You heard you were in here, Judge.
For anybody, but from both sides or either party.
When he made that statement, yeah, I
Yeah,
backed
there's a
off.
good reason for it. That's so
Right.
that people don't sit in there and listen to the testimony and then get educated on what they might be saying later. All right.
Adams did not indicate.
She's
that
gonna
he had-
test, I'm gonna let her testify, but the problem you have is when they sit in the
Right.
room and listen, that kind of takes a little of the sting and emphasis and the accuracy of what their statements are, and that's why we developed the rule of sequestration of witnesses is what it's legally called.
Well, let me ask
People
you.
are outside and they don't hear what other people are stating, so that they don't get educated of other information
Yes,
that
sir.
would add to what they already know, which is what they should be testifying to, just what's in their mind, not what other people are telling them who are testifying in the same.
And I apologize, Judge, for the.
Go ahead,
confusion.
ask.
Oh, okay, with that being said, let me ask you an opening question. You ask it any kind of way you want to, okay? Do you know if your son was receiving any kind of medications at the time of this alleged offense on February the 15th of 2026? You can tell me if you know or you don't know.
On his meds.
Why do you believe that? And you can answer it any way you want.
Because of his, reactions. They were, I mean, he was all over the place, you know, his emotions. Because he wasn't on his meds.
Okay. Now,
Hold on, let me get this clear. Was that his choice? Because he wasn't feeling good on his medication?
No.
Well, who told him to stop?
He hadn't stopped, Your Honor. He had ran out, so he. was
Okay,
waiting.
so why didn't he go get it filled?
That has to do with the top.
With what?
The place where he gets his
All
meds.
right. Okay.
The top.
all right.
Go ahead.
They were supplying his meds. They are the reason why.
Well, why
he
isn't
ran
he
out.
going to Spindletop to get his medication? Why wasn't he getting his medication? Spindletop wasn't refusing ordered medication by doctors. They don't do it that way. Why wasn't he going to
He had
Spindletop?
to wait for them, sir. Your Honor, my understanding is that when he ran out, he had to wait on them. Then
Who told you that? Who told you he was having to wait on them?
I experienced.
Oh, you don't know for sure.
Well, I guess I don't.
You weren't present
No,
with him at the
right,
time.
no.
So you must have heard it from somebody else, I guess.
I heard it from my son because I was trying to.
Okay, your son was telling you?
Meds.
All right, go ahead.
Okay, so I remember I told you I was gonna be short, so let's get straight to the point of why you're here, all right? Did you hear Judge point out that you're the victim on this underlying offense of injury to the elderly, right? And you also understand that we're here for a motion to revoke your son's probation, right? You understand that? And you also understand, as Judge pointed out, he is the decision maker on this motion to revoke. You understand that, right? So here's the open-ended question I want to ask you, and I'm gonna sit down, all right? Could you tell the judge, as the victim of the underlying offense, in your own words, look at him, why you want him to continue your son on probation? Why? And you can say whatever you want to that.
Objection is to relevance.
It's sustained.
All right.
But actually, I'll let her speak.
Okay. Tell him in your own words why you want him to remain on probation. Why?
Your Honor, my son needs intensive medical health treatment.
How do you know that?
This is not my field of expertise.
It's not, is it?
No, it's
No.
not, but I suffer from some of these same illnesses. So he's been through a lot. He's been sexually abused. He's been emotionally abused.
Were you present when that was happening?
I'm his mother.
No, I know you're his mother. Were you present when that was happening? Okay, you just heard that from others?
No. What happened?
How do you know that happened?
My perpetrator in the army stole him, his brother, and his sister from me. So yes, I know.
Well, how do you know what was happening when you weren't there?
I wasn't there, but I was there. I was not ever there. I was there indirectly because the
Indirectly.
perpetrator stole him and took him to Michigan.
Well, how do you know what happened when you weren't present?
Because the children were brainwashed. I wasn't.
How do you know they were brainwashed? You weren't
I was
there.
going to court, back and forth.
I know you were going to court, but you weren't present at the event, right?
But
You can't do, so you weren't a witness.
when you're on it today, you're right, I wasn't present. So I'm speaking from me. I suffer with these illnesses. I have PTSD. My perpetrator is a result of the United States Army, okay? And my son has been, he needs intensive mental health because he's ODing on fentanyl. And he lived
Wait a
to
second.
tell about.
Where is he getting fentanyl from?
I'm just.
No, where did he get fentanyl from? That's an illegal
This
drug. That'll kill you, much less brainwash you.
I'm telling you, Your Honor, my son OD'd on fentanyl, but he's here today.
God bless you.
He's a, I got a picture. I'd like to show you.
No,
my picture,
ma'am,
Your
ma'am,
Honor.
hold on. I don't disagree with you, but
I'm telling you
fentanyl,
myself.
where is he getting fentanyl
I
from?
don't know where he got it
So you
from.
don't know a lot about your son then, do you?
Your Honor,
Do
what I
you?
do know is that my son needs intensive.
Fentanyl was not prescribed by the doctor,
Your Honor.
was it?
It was, he OD'd on fentanyl.
That wasn't prescribed by the doctor though, was it?
No, no.
No, it's not.
No, it's not.
He's getting it on the street somewhere.
Yeah, yes,
Right?
Your Honor, yes.
That's a crime.
There is a.
He's on my probation. He's not supposed to be getting fentanyl on
Your
the
Honor,
streets.
my point is, my son OD'd on.
The point is, he's committing crimes while he's on my probation.
But you know, he OD'd, Your Honor.
It was his choice to go find the fentanyl, right?
Yes, sir. But
God bless you. God bless you.
Your Honor, all I'm asking for is intensive mental health therapy for
But
my son. That's all.
all I have ordered is for him to follow the rules and not commit crimes. And the more you speak, the more I learn he's not following the court's order.
You know, but this was in like 5 years ago, almost, when he OD'd.
I wish you'd have, yeah, I wish, he's been on probation for a long time here now.
You know, Your Honor, I'm just asking you if you would please consider.
He sees you regularly, doesn't, you and him see each other regularly, don't you? You see him regularly, don't
You
you?
know, I don't see him regularly. He's homeless.
But I mean, when you see him from time to time.
Oh, yes. From time to time, I take him food.
I know.
I bring
But
him food.
one of my court orders is he's not supposed to have any contact with you unless I approve it. I've never been asked to approve anything. I mean, every time you're saying something, it's a violation of his probation. I'm not sure you're helping him here.
Oh, I'm sorry about that, but when I bring him food, I bring it to his friends and leave it, you know.
All right.
That's what I do. So I bring him food. Your Honor, I'm sorry,
All right.
but yes,
Well, that's a
And
court
he was
order
hungry,
and,
you
you
know.
know, we don't want to be violating court
No,
orders.
sure,
Oh, okay.
sure.
Oh, good.
but I do, Your Honor, want to ask you, please, consider, committing my son to, mental health, for, intensive therapy. I'm getting therapy right now, Your Honor. I do
For
therapy
what?
For, PTSD or MST.
How long have you been getting treatment for that?
I've restarted working, but I've been in the mental health, realm for a long time.
Okay.
So, I just restarted my, mental treatment in March 24th.
Well,
And so,
yeah,
I do,
you can't help but love your children. I know that. I've got children. But the children should not ever, ever, ever harm others, much less their parents. Their parents are special.
yes, sir.
They should never harm their parents, and he was convicted of harming you.
Yes,
He's
sir.
on probation for harming you.
Yes, sir.
And the most important condition I had was to make sure that further bad things don't happen. And here we are. We're back, and I'm very proud that the probation office is because of it. We have a success rate. That's 13 out of 14 failure. And that's 1 out of 14. I want 100% success. But these are actions that I'm hearing about more criminal behavior and failures to follow the terms and conditions of probation, which the court ordered. That's why I hate failure. I want to see success
Yes.
all the time. And one of the problems is that you can help him with this, but the court order that we have in place is he's not supposed to have any contact with you. And I'm willing to change that, but nobody's asked me. And that means that people are changing the rules, and I'm the rule maker on probation, on my probationers. y'all are going behind the scenes and doing things they shouldn't be doing. And here we are, I'm listening to them and everybody's getting in trouble here. The more I hear, everybody's getting in trouble. It's one bad thing after another I'm listening to, and I haven't approved the behavior that's resulting in these acts I'm listening to. I mean, you gotta follow the rules first. That's the way the law is. Those are laws. Next,
I don't have any
through with this,
questions.
like, okay, thank you.
Come on, Mr.
Yeah. Next, you're,
That's it.
all right,
That's my only witness.
go ahead. Summary, anybody?
Want me to go?
They can go first and last. Under the rules. They're passing?
I'll pass.
Go ahead.
Judge, what I'm asking you to do in this case is to continue him on supervision for one overwhelming reason is he has documented mental illness, absolutely documented. And I confirmed that documentation with the probation officer himself, Mr. Ruiz, on the schizophrenia, the bipolar, the PTSD, the anxiety disorder. And even their witness, not my witness, their witness came up here and told you, hey, evidently, and I wrote it down, evidently he was out of his mind. He's not in his right mind. That's their witness saying that.
Who are not medical experts in that regard.
But their witness said that. And
Has anybody ever told you you're not acting in your right mind?
well, I mean,
But you're not going to say.
But I didn't do anything like this. But here's where I'm going with that, though,
By
Judge.
the way, Mr. Kimmler, who is an expert witness in that regard, could have been called, but he was not called. But let's, once again, what we're talking about are medical diagnoses. And
he has them from spontaneous majority. He's been diagnosed. They confirmed that.
Okay, keep going.
Right. The probation officer confirmed that he has those diagnoses and he was getting the 4 medications that he named. Mm-hmm. And Judge, what I'm saying is that just the offense themselves on the burglary of the habitation, their own witness said, I'm not saying he was burglarizing my house. That's a quote, direct quote from their witness. Word for word.
We're going to rely on what the elements of the offense are based upon the evidence as prescribed by the penal code.
Yes, sir.
It's a lay witness. He's going to testify, but we're going to rely on what was said, what's in the record.
Yes, sir.
What the elements of the crime are as described by the penal code, not a layman.
Yes, sir.
But so he doesn't decide whether a crime is committed or not. It's going to be the law and the evidence that was presented, and that's what we rely on.
But Judge, I was just pointing out what you and I heard. We both heard the same thing when the man said, "It's not no burglary." I mean, you heard him say it. I heard him too, and I was just pointing that out. And then I also wanted to say, Judge, as far as on the indecent exposure, him doing what he did went more to his mental illness than to anything about sexual gratification or anything like that. My position is that if we were to believe the probation officer who had him for 18 months and this person said, hey, in 18 months, I hadn't seen this kind of behavior at all. If we to believe Mr. Williams, who knew him for 2 months and said, hey, I hadn't seen this kind of behavior at all. Obviously, on February the 15th of 2026, this was a guy suffering from a mental condition who did not know right from wrong at that time. And I'm attributing that mental condition of not knowing right from wrong to the behaviors that we saw. And your probation officer, and I got it out of him in his testimony, his exact words is the Jefferson County Probation Department is equipped to continue him on probation and give him the treatment that he needs and continue him with the treatment that he needs. So I was going to ask that you keep him on probation, even if we were to take Mr. Ruiz's words for what they are. As far as on the violation of not reporting in January, I understand testimony to be as he had pneumonia and he had COVID. I got their witness to say, hey, I don't want somebody coming into my office with COVID either and pneumonia and report having a contagious disease. As far as number 5 is concerned, verification, Judge, he provided his phone and the phone showed that he did do the classes. I'm I'm going to the battering. Let me go back. As far as the community service is concerned, it's my understanding that because he was working and employed at KFC, my client wasn't able to do those community services hours because he was basically working. They abandoned number 5, and then when it goes to 6, that he was in arrears in 2000, having $2,735. I'll respond to that by using the state's witness again. Remember, you the one who brought up, Judge, and when the state witness said something to the effect that my client got a lot of things going on, and when we looked at his mental illness, what was going on with his family, what was going on with him at work, all those things contributed to him not being able to pay those fees. So, Judge, what I'm asking is that considering that the offer in this case was 10 years in the pen, and my client rejected that offer on the motion to revoke probation, I'm asking you to continue him on supervision. This is not a guy that needs incarceration. This is a guy who needs continued treatment, as your probation officer said. And most importantly, and here's where I'll sit down, Judge, the biggest person that's asking for you to keep him on probation is the very person who is the victim in this case, and that's his mom. His mom testified, and I asked her to tell you whatever she wanted to say. It wasn't no leading questions. It wasn't me suggesting the answer. I said, tell the judge whatever you want to tell him. And you heard her with your own ears that she wants her son to be continued on supervision. So I'm asking you, if you don't do it for my client personally, do it for the victim, which is his mother. His mother wants him to be continued on probation, and we're asking the court to honor at least her wishes, because you heard it with your own ears. You heard what she said. She wants her son to remain on probation, and I know the court heard her say that. So I'm asking the court just to honor what she wants, and she's the underlying victim in the case. And that's why I was asking for those things. I thank you, Judge, for your time.
Okay. Go ahead.
I'm going to stand by the evidence and ask that you find the accusations true.
All right. The evidence is before the court in this motion to revoke probation. It is alleged that the defendant committed the offense of burglary of a habitation on or about February 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of the defendant's community supervision order. What does the state say about that? I'm going to go down each one. Okay.
As far as that is concerned, at the very bare minimum, he testified as to the lesser included offense of criminal trespass, Judge.
Oh, really?
He did. He said the man came into his house without his consent. He asked him to leave and he didn't do it. He had to forcibly remove him. That's the testimony that's before the court.
All right. Then let me cite to you State versus Meru, 414 Southwest 3rd, 2013, in Bont Court of Criminal Appeals. Criminal trespass is not a lesser included offense of burglary of a habitation. Why? They make it clear. The burglary of a habitation, breaking of entering, is a different version of what it is defined as for criminal trespass. Burglary is committed if you partially enter into habitation. Criminal trespass requires full entry. That's why they said there is a difference. And it is not it's not been a lesser included since 2013.
All right. So as to the elements of burglary, person commits that offense if it's without the consent of the owner. We had the owner here. He said he entered his habitation.
Yep.
That's parent 1 enters the habitation, and he did that without his consent.
Yeah.
Let me stand by that, Judge.
Let's just wait, hold on. And burglary, you didn't complete all the elements and to commit a felony offense.
Look, I don't think there's no evidence of that, Judge. None. There was no evidence of that. And we also challenged the consent because he did say he opened the door.
Burglary, a person commits the offense if without the effective consent of the owner enters a habitation or building not been open to the public with intent to commit a felony or an assault or felony theft or assault, that doesn't apply. 2, remains concealed with intent to commit a felony theft or an assault in a building or habitation. That doesn't apply. 3, enters a building or habitation and commits or attempts to commit a felony theft or an assault. That's it. Where does that?
It doesn't, Judge.
Okay,
I
so.
was relying upon criminal trespass.
Okay, and criminal trespass is not a lesser included offense.
Yes, sir.
So burglary habitation allegation 1 was not proven.
And Judge, will we better rely on the legal issues of res judicata or issue preclusion? Because if he's indicted and the court has made the finding, then we would be entitled to use that as a defense. If the state should try to indict him on burglary habitation, you have made a finding, and we would ask that finding so it can be used as an affirmative defense.
The court has made a finding that it was not proven by preponderance of the evidence or greater. It's up to a grand jury. If they want to indict, they will indict on what evidence is before them, which can be different from the evidence presented at this hearing. So no, you're not going to prevent a grand jury from doing lawfully their job. And that does not preclude the state from supplementing information in front of a grand jury that might be different from what was in another proceeding. So.
Thank you, Your Honor.
Number 2, committed the offense of indecent exposure. What do y'all say about that? State stands by it.
I stand by the evidence.
All right, anything from the,
I say, it was not proven.
okay, section 21.08 of the Texas Penal Code, let's talk about the law. Describes what constitutes indecent exposure. A person commits an offense if he exposes his anus or any part of his genitals with intent to arouse or gratify the sexual desire of any person, and he is reckless about whether another is present who will be offended or alarmed by his act. An offense is, under this section, is a Class B misdemeanor, except that it is a Class A if it is shown on the trial of an offense the defendant has previously been convicted of one time of such an offense, and it becomes a state jail felony if a defendant has previously been convicted 2 or more times.
And Judge, there was no witness who said that he did that for sexual gratification or to arouse himself. As a matter of fact, it's just the opposite. The opposite is even from their own witness that they believe that he was out of his mind and not in it. So him exposing himself was due to him by their own witness being out of his mind, not exposing himself for purposes of arousal or sexual gratification.
Okay.
So I would say that they haven't proven that. Not one witness, not one, and you heard it all, said that he went in there for sexual
You
gratification.
already said that several times.
So
Yeah. And
not one.
yeah, okay, yeah. Being an advocate, I disagree with you completely. I can draw reasonable inferences, and any jury is allowed to draw reasonable inferences from the facts. Somebody taking out his penis in somebody's house when he wasn't invited, and making masturbation movements. The court is going to infer that he was doing that to fit the element of attempting to arouse or gratify the sexual desire of the defendant. That is a crime. It's a misdemeanor. It is alleged in number 2 that he committed the offense of indecent exposure on or about February 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of his probation order. I find that true beyond a reasonable doubt. Failed to report to the Jefferson County Probation Office for the month of January 20.
6, and failed to to provide verification of performing community service hours as required. Go ahead. What do y'all want to, anything to add on those last two?
On those two, Judge, you wouldn't want him to come report to you with those illnesses. I know
Once again, just make your argument. Don't
Right.
bring me into the witness for.
The point I'm making, Judge, is based upon what their own witness said, and their witness even showed you the medical confirmation. He was legally and factually and physically unable to report for January due to having pneumonia. And
You've said that, you made it clear. I want to know what the state's position is.
That medical excuse that was offered was from November 10th.
Yeah.
These are from January of 2026.
But
that was like 2 months before. What about that? How do you explain that?
I explain it because what Ruiz testified was to January. I understand Mr. Ham's point when he's talking about the date of the excuse.
Yeah, isn't that important?
But the testimony was he had those illnesses in January.
Who said that? Who was testifying that? The defendant? Right?
No, that was Mr. Ruiz, the probation officer, because I had him on the stand.
Now, how was he diagnosing him?
No.
I know they have a lot of authority and they're smart people, but they didn't go to medical school. So how much weight are we giving to someone? What I want is a doctor's excuse. We don't have that. It's just statements being made by people who are non-medical experts.
The only thing I can say, Judge, is that Mr. Ruiz, the PO, believed in January that he suffered from those ailments. He believed that based upon his testimony.
The state clarified it.
Statement. That is not what.
Yeah, I don't remember him saying that under oath.
When you asked him, he said the only medical information was predated.
Court finds that there is sufficient evidence supporting that allegation to grant it by a preponderance of the evidence or greater, as the court finds the defendant failed to report to the probation office for the month of January 2026 in violation of condition 4 of his probation order without a sufficient excuse. 4, failed to provide verification of performing community service hours as required.
Working at KFC is our response to that. That's why he couldn't do them.
Okay, state response.
Judge, he did 4 out of 600 hours. That in and of itself, in the time frame that was provided, tells me that he didn't work faithfully at doing community service hours.
How about that? Doesn't hold on.
I'm sorry, Judge.
Doesn't the dramatic difference between the amount that he could have garnered for reporting versus the actual amount, which is minuscule over this vast period of time, which was he was on probation 2023 and we're talking about through earlier this year, January. I mean, we're talking about community service hours for one half of 23, half a year for 6 months in 23, all 12 months in 24, 12 months 25, 24 and 6. That's over 30 months, and he's only done 4 hours.
But Judge, in fairness to him,
I mean, doesn't the math just not work out?
right, but I was going to add to that math, though. You also got to consider, though, with him being on probation for 10 years, he still had 7 more years to complete all of that. So I want to give him the benefit that he had an additional 7 more years that he would have had to complete. And if the court is willing to continue him on supervision, I have confidence he's going to get that done, considering he got 7 more years.
All right. The court will find true allegations 2, 3, and 4 was proven by a preponderance of the evidence or greater. And in allegation 2, indecent exposure was proved beyond a reasonable doubt. And failing to report is number 3, failing to provide verification of performing community service hours as required. And the court finds that those are violations of this motion to revoke probation, and the court finds shortly to those. All right. And that is enough to grant the motion to revoke probation in this case. What do we do next?
Judge, I'm arguing that with him having that mental health condition and that with the probation department saying that they are willing and able to continue to treat him is to keep him on supervision. We did reject a 10-year offer, but we're asking to keep him on supervision.
What state?
Because of what the probation department said.
Okay, what state saying? What state requesting?
I think it should be revoked, Judge. The behavior on February 15th, I get that it legally it doesn't fit the burden of habitation, but that we know it was trespass. We know that his conduct, as the witness says, was just not right. Every one of us would not want somebody to come plop down in our room. We ask them to leave, they don't leave, and then they pull their pants down and wag their penis at you. It's that conduct in and of itself needs to go to prison. And we add to that he was on probation and looking at his PSI, the amount of criminal history this man had. We gave him a break, giving him probation in the first place. I'm just a staunch believer that if you give somebody with a record that kind of an opportunity and they fail, then it's time to send them to prison.
Anything else by anybody?
That's it, Jeff.
All right, the court will find that there is sufficient evidence supporting this motion to revoke probation in cause number 22-40987, the state of Texas versus Cortland Julian Hardwick, to grant it by preponderance of the evidence or greater, as the defendant had pleaded guilty and was found guilty of the third-degree felony of injury to an elderly person, namely his mother, in this case, and was sentenced to 10 years in prison, and that was suspended. He was placed on regular probation based upon these findings of the court that the defendant, it is proven true in this hearing that he committed the offense of indecent exposure on or about February 15th, 2026 in Jefferson County, Texas, which is a violation of condition 1 of his probation order. The court finds that not only by preponderance of the evidence or greater, but beyond a reasonable doubt, and that 3 and 4 of the allegations of violations in the motion to revoke probation, namely failing to report to the probation office as directed and failing to provide verification of performing community service hours as required, were proven true as violations by a preponderance of the evidence or greater. So thus, those were violations of his probation, 3 violations of probation of condition 1, condition 4, and condition 18 of his probation order have been proven true. This motion is hereby granted, and the defendant is hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. Let me just say one thing. There's been a lot of discussion about his mental health, yet nothing was presented in this court medically to show anything, a scintilla of evidence that he was incompetent or insane. Nothing has been shown. You're presumed otherwise. His actions are bizarre, but we see bizarre things all the time in this court that don't have anything to do to incompetency. Generally, it's drug usage or some other physiological issue, but generally, incompetency is rare to be found, but it requires something other than lawyer arguments. And nothing was shown. And nothing was shown when we put him on probation. I made a finding that the defendant was competent to stand trial. There wasn't an issue on that. There wasn't anything presented otherwise. Sure, he has he has shown bizarre behavior, and he's being held accountable for bizarre behavior. But nothing shows in the record that the defendant was unable to conform his conduct to lawful behavior because of some medical reason. Thus, he is held accountable just like all of us. Shame on you for your actions, especially going in and committing a terrible offense of pulling your pants down and waving your penis to neighbors. Shame on you for that. We've had situations in this court where people pull out a gun and shoot the person in the head for that and shoot them somewhere else for good measure. But nonetheless, you're presumed sane and presumed competent unless otherwise shown. That means you have to follow the rules like all of us, sir. And you're going to be held accountable when you don't. That is all. We're in recess on this case.
Thank you, Your Honor. Yes.